Good morning and welcome to the Public Service Commission's administrative meeting for November 3rd, 2021. Before we start the meeting today, we have some comings and goings of staff. Coming on board is Patricia Brown. She's a new investigative specialist with us in the Transportation Division. Ms. Brown spent the majority of her career with the FBI in Washington, where she worked in various administrative roles, including as a paralegal specialist. She gained extensive knowledge there with many databases and administrative processes. So Ms. Brown will be a welcomed addition to our staff upstairs on the 18th floor. Welcome, Ms. Brown. On a more bittersweet note, we are losing a valued employee at the end of this week. Afton Hauer is a regulatory economist with our electricity division. She's been there for 2 years. She initially started as an economist in the telecommunications, gas, and water division. Happy to announce that Afton will be moving to a very well-respected consulting firm here in the state to lend her expertise. I'm sure we'll see Ms. Hauer in the near future in a different capacity. So congratulations, Afton, on your new position. With that, we have meeting minutes to approve from the last administrative meeting of October 27, 2001. All in favor, please say aye.
Aye.
Any opposed? The meeting minutes are approved. Good morning, Mr. Secretary.
Morning, Mr. Chairman. There are 3 items on today's consent agenda. Items number 1 and number 2 are tariff revisions regarding 8YY access charge reform from Fusion Communications LLC. And item number 3 is an application from the Shekels residents for certification of a geothermal heating and cooling renewable energy facility.
Thank you. Do any commissioners have questions on these consent agenda items? Seeing none, I would move that with respect to item number 1, that we accept the tariff revisions for filing with an effective date of July 1st, 2021. With respect to item number 2, I move that we accept the tariff revisions with an effective date of October 2nd, 2021. And with respect to item number 3, I move that we approve the application and issue a renewable energy facility certification number and energy savings estimate, that we direct the applicant to establish a REC account with PJM GATS within 30 days of certification and file a geothermal and thermal biomass generation report with the Commission within 1 week of each recording of generation data with GATS of RECs created. And finally, that we direct the applicant to file notice with the Commission within 30 days of any change to the information in its application. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motions are approved. Mr. Secretary, the administrative agenda.
Mr. Chairman, item number 4 on the administrative agenda is an application from Neighborhood Sun Benefit Corp. For a license to supply electricity. On this item for staff, we have Nan Zhang and Catherine Mackerlane. For the company, Gary Skolnick and Ian Sneed.
Thank you. Good morning, staff. Ms. Zhang, if parties could please turn on their cameras as their items are called. Thank you. Ms. Zhang, Ms. Mackerlane.
Good morning, Chairman, Commissioners. Nan Zhang on behalf of staff. On June 23, 2021, Neighborhood Sun Benefit Corp. filed an application for a license to supply electricity or electric generation services in Maryland. The company's founder and CEO, Mr. Gary Skolnick, was the co-founder, president, and CMO of Clean Currents, Inc. In March 2014, Clean Currents dropped its electricity customers without notice due to its default with PJM. Additionally, Clean Currents subsidiary CCES LLC had an outstanding commission assessment in the amount of $3,561.47. Instead of directly purchasing wholesale energy or hedges in the PJM market, Neighborhood Sun will receive all purchases through Gulf Power, Inc. Gulf Power is an experienced PJM member and a significant investor in Neighborhood Sun. Gulf Power also provides a credit facility for Neighborhood Sun with a credit line up to $750,000 to start, with the ability to increase the limit beyond that. Staff recommends that the Commission grant the company a license to operate as an electricity supplier in Maryland, with the condition that in the event Neighborhood Sun terminates its operations with Gulf Power, Neighborhood Sun will notify the Commission in writing. Thank you.
Thank you, Ms. Zhang. Before we turn to the applicant, are there any other parties that wish to speak with respect to this application? Hearing none, we'll turn to Mr. Gary Skolnick with Neighborhood Sun Benefit Corporation.
Thank you, Mr. Secretary and commissioners. I don't have a lot more to add. I want to thank the staff for their investigation and look into how Neighborhood Sun would act as an electricity supplier. I also do want to take responsibility for the oversight of not reporting in our initial application that I had served as president of Clean Currents, something that was important for the Public Service Commission to know. So I am sorry about that oversight. But we appreciate the staff's review and are available for any questions. My colleague Ian Sneed from the executive director of Galt Power and board member of Neighborhood Sun is also on the call and available to answer questions as well.
Thank you. At this time, we'll take questions from commissioners, beginning with Commissioner O'Donnell.
Thank you, Mr. Chairman. Let's start with staff. Ms. Mackerling, can I ask you, from your perspective as staff counsel, the condition that Neighborhood Sun notify the commission if it terminates its operations with Galt Power, what would that notification trigger? What would the legal recourse be? What would we do if they did and they notified us?
Well, really, it would just put staff on notice to keep our eye on a Neighborhood Sun. We could contact the Consumer Affairs Division, make sure they're not getting any complaints. Because their relationship with Galt Power is a strong factor in why we found them to be have managerial competence. It's important that staff's aware of their relationship and also to keep their contact with the Maryland Public Service Commission due to the fact that we had to do extensive investigations into their managerial competence. It just, for now, I think it would be a helpful part of their application as a licensed energy supplier while working with the commission and staff.
Ms. Zhang, anything to add?
No.
Okay. Mr. Skolnick, your previous affiliation, you dropped your customers without notice and you basically defaulted on a $3,500 plus assessment to the commission. Why should I have any confidence that you are not going to do any similar act going forward?
Well, thank you for that question. It's on the first instance, I would say that people learn from their mistakes, and the mistakes that happened at Clean Currents have taught me lessons that will be with me for the rest of my life. So having gone through that experience, I know much better how to avoid it. And that brings me to the second instance, which is that having gone through that, we now are approaching the market in a much different way. By partnering with Galt Power, we are not taking the same kind of credit risk that Clean Currents took back in the days. And we are taking a much more conservative approach. And at the end of the day, it's the customers who matter. And I'm very happy to say that many of Neighborhood Sun's customers today for community solar are former Clean Currents customers. We had a great track record at Clean Currents, not a single complaint about the way we operated. As you guys all know, there's a lot of issues with how some retail suppliers operate in the state of Maryland. Clean Currents was the exception. Our customers loved us. They were willing to pay a premium. That was a green power option, so they were all paying a little bit above the utility rate. Unfortunately, when Clean Currents went out of business, they went back to the utility, but it didn't actually cost our customers any money because they had been paying a previously higher rate.
Right, but you defaulted on an obligation to the citizens of the state of Maryland. Why should you never made good on that default?
Well,
why should I be sympathetic to that?
structure of Clean Currents is very different than the structure of Neighborhood Sun. So when Clean Currents went into default with PJM, we had a senior debt holder who was calling all the shots. And as the president of Clean Currents, my only option really was to resign and protest or just to finish things out. But the senior debt holder is the one who decided to default. Actually, one of our investors, Stephen Fernandez, who is the owner or one of the owners of Galt Power and Customized Energy Solutions, was pleading with this debt holder to keep Clean Currents in business because we had a large book of business that actually could have been profitable after the polar vortex, but he decided not to do it. Neighborhood Sun's a completely different story. We have Galt Power on our board of directors. We don't have a single debt holder who controls the fate of the company. We have a board of directors that controls the fate of the company. And I am in charge. I'm the CEO this time, and I get to call the shots along with the board of directors. So it's a very different situation.
So you don't feel any personal obligation for defaulting on that assessment?
Oh, I do. I feel
You seem to pass the buck to that senior debt holder.
Well, I'm not a big fan of passing the buck, but if it's the truth, it's the truth. And if I had the ability to make the decision, that never would have happened. I personally felt horrible about what happened at Clean Currents, and anybody who knows me knows that it was a very rough period in my life when my baby went out of business. As an entrepreneur and a businessman, I think people can appreciate that. And when I went back and started Neighborhood Sun, I did it with a lot of humility because I wanted to make sure that people still supported us. And I'm happy to say that they do. The original Clean Currents customers have signed up with Neighborhood Sun. In our application, we had many letters of support from people. I hope that's in the packet there. And, we want to do it right. We had an overall positive impact on the state of Maryland. We helped reduce greenhouse gas emissions, increase clean energy usage, and we acted in a fair and ethical way that was a model for other retail electric suppliers to follow.
Well, staff still has concerns about your technical and managerial competence, and you have previous violations of COMAR and you defaulted on your obligation to the citizens of the state of Maryland. And for all those reasons, I have concerns about granting you a license again. I think to our transportation division, if I had a driver for hire who had done something similar and they came back sometime later asking for a license again after we had just took their license previously with prejudice, even though it was a different entity, but they come back under a different name and a different arrangement, would I grant them that license? And in my mind, I'm going to operate under the principle of fool me once, shame on you. Fool me twice, shame on me. So I just have concerns, Mr. Chairman.
Thank you. Do other commissioners have questions of the parties? Commissioner Linton.
Yes, thank you, Mr. Chairman. I had a couple of questions for Mr. Skolnick. Since your prior experience with Clean Currents is part of this application, help me to understand when you defaulted with PJM and your customers were returned back to BGE for the default service. What was the reason for doing it?
So thank you for the question, Commissioner. The polar vortex hit in the winter of 2014, and PJM wholesale energy prices went up exponentially. Clean Currents did not have sufficient coverage to hedge against that. And PJM hit us with a extremely large bill that we owed, and we had about a week to pay. we went to our lead investor, the senior debt holder, and said, we would like to pay this. We think that this polar vortex is a temporary problem. People like Stephen Fernandez said the same thing. And the senior debt holder said, nope, we're not going to do that. He took some advice from somebody who told him that if he defaulted on PJM, he might be able to recover some of his money. And I protested. I said, this is not the right thing to do. We have a great business. We have all great customers. I reached out to other companies like Washington Gas Energy Services and Constellation and others to see if they would buy the company. And they were willing, people were very interested in doing so, but we only had a week to solve it, and without getting additional money in. But no additional money would come in unless the senior debt holder was willing to take his position down a notch and not be the senior debt holder. He refused, and so the company defaulted on PJM. And once that happened, then we had to inform our customers that what happened, and we had to unwind operations. And I would just point out that unlike the example of a driver, this is a corporation. Corporation is not the same as someone driving a truck. Corporation has many people making decisions. And I was a member of that corporation. I was protesting the decisions, but they got made despite that.
Okay. Well, thank you very much, Mr. Skolnick. I appreciate the answer. Thank you, Mr. Chairman.
Thank you. Any additional questions? Commissioner Richard.
So it's a question, but I just wanted to state that I've known Gary Skolnick for quite some time, and I've always found him to be a very person of high ethics. I've always admired his acumen in this particular industry, and I just find him someone who's just he has admirable, I guess, mission-driven kind of endeavors, and so I've always just been very impressed with his ability to run organizations and to get things done. So I not really a question. I just wanted to state that for the record.
Thank you. I recognize that Commissioner O'Donnell has raised some serious concerns, and I've also reviewed not only the applicant but a number of the other correspondence and pleadings that were filed in the record. The polar vortex was a situation that we all remember very vividly, and it had littered the market with a number of retail supply entities that weren't able to meet their obligations. Of course, Clean Currents being one of them. That being said, with the conditions in place, the different organizational structure, and the commitments with Galt Power, I am comfortable with the arrangement going forward, subject to these conditions. With that, I will propose a motion that we grant the company Neighborhood Sun Benefit Corporation a license to operate as an electricity supplier in Maryland, that we direct the company to notify the commission in writing if the company terminates its operations and arrangements with Galt Power Incorporated, that we direct the company to provide marketing materials specific to its Maryland operations to both commission staff and the Maryland Office of People's Counsel 30 days prior to the utilization of those materials in Maryland, and that we direct the company to file notice with the commission within 30 days of any changes to the information in which we're granting this application. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye, and I'll just note, Mr. Chairman, if I could, for the record, that there's a lot that happened during the polar vortex that Mr. Skolnick didn't share with us today. And so that information, it's his story to tell, so I won't present it in this case, but there's a lot of good reasons what to vote aye in this case. So I vote aye.
Commissioner O'Donnell.
Thank you, Mr. Chairman. Let me just say that many of the transportation entities that we license in this state are corporations. I'm not talking about a truck driver. And so I want you to know that we do license corporations for transportation purposes. And I think that's important. So it's a distinction that means nothing to me to say a truck driver. You try to minimize it. And I see a lot of minimization going on here, and I just have concerns about it. I'm hoping we don't see you again, Mr. Skolnick, in a bad light. And I hope the message goes strong with my vote that if we do, it's probably not going to be giving you the opportunity to come back in less than 8 years and get another license for something in the state of Maryland, in my opinion. I probably won't be here, but I have a lot of concerns, and I'm going to voice those concerns on behalf of the citizens of the state of Maryland. I vote no.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 5 is a request from Untrust Energy East, Inc. to cancel its electricity and natural gas supplier licenses. On this item for staff, we have Kevin Mosier, Nan Zhang, and Catherine Mackerlane, and for the company, Jimmy Parrish and Brian Green.
Thank you, Ms. Zhang again.
Good morning, Chairman and Commissioners. Nan Zhang on behalf of staff. On April 6, 2021, Untrust Energy East filed a request to the Commission to cancel its electricity and natural gas licenses. On August 5, 2021, staff was notified by the United States Bankruptcy Court, Southern District of Texas, Houston Division, case number 21-31070, which required the sale of Untrust's RECs. The company owes $902,505 in alternative compliance fees for 2020. Staff requests a finding that Untrust is unable to meet its Maryland obligations and that the Commission collect on the company's surety bond. Thank you.
Thank you. Counsel for Untrust Energy East Incorporated. Mr. Green, your microphone is off.
Sorry, you would think after over a year of this, I would have learned that. Brian Green for Untrust Energy East Inc. Mr. Parrish is unable to join us this morning, so I'll be hopefully answering any questions you may have. I mean, if you would like me to, the company, correct, Ms. Zhang is correct. The company filed for bankruptcy protection on March 30th of this year. We filed a material change update on April 6th, had some discussions with staff shortly thereafter, and filed an updated letter on April 12th, clarifying that we were seeking to surrender our license or requesting that the Commission cancel the license. There are no current Untrust customers in Maryland, nor has there been in quite some time. I'm really just here to see if I can answer any questions. There's really nothing more I can add.
Thank you, Mr. Green. Questions from commissioners. Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Green, remind me what the what Untrust's obligation to the state of Maryland was at the time of its bankruptcy.
Its obligation as far as
Dollar amount. The dollar amount.
I didn't hear you. The dollar amount of the rec payment?
Yes.
Okay, I believe in staff's buck sheet, they peg it at in about approximately 950,000. I don't have the exact number in front of me.
And what is your bond for?
250,000.
So we collect a quarter of the obligation of the company through the bond recoupment.
That's right.
And where does that bond money go?
I don't know. I mean, if it's
Staff, tell me where that bond money goes.
I believe the money, this is Kevin Mosier on behalf of staff. I believe the money would go to the comptroller's office. That's where normal alternative compliance payments go.
The what? Here.
The comptroller's office.
Oh, I thought it went into an education fund.
Well, it originally goes to the comptroller's office, and then it would go to the Maryland Energy Administration.
Okay. All right. So we're collecting a quarter of the obligation Well, I guess there's not much we can do about it, but it sure doesn't feel right to me. I don't know why I'm in such a bad mood this morning, Mr. Chairman. Must have been my drive up here this morning.
The, to the extent there is a remainder, I guess there's an opportunity, and the commission should have received notice to file a claim with the estate. That's my understanding with the bankruptcy court, that's the process for unpaid debts.
Commissioner Richard.
Yeah, that's an interesting point. So would it be up to the Maryland Energy Administration as, you know, the custodian for the SEIF to try to collect that money?
If you're asking me, Commissioner,
Yeah, you just brought the point up. I mean, is that, if someone doesn't pay their alternative compliance fee, where, you know, how would one collect that? Would that be up to the Maryland Energy Administration?
Mr. Irwin.
What do you say?
That might be a question for Mr. Irwin.
Okay, well, I'm just curious, you know, for retail suppliers, if they've even given that thought. So, I mean, that is an obligation that retail suppliers need to consider how they're going to make their payment to the compliance, you know, to be in compliance. So I don't know, does staff know the answer to that? Maybe we ought to let the Maryland Energy Administration know that some money is owed them.
Commissioner, it's not actually clear to me which state agency would be responsible for collecting that within the context of the bankruptcy proceeding. As Mr. Mosier said, it does normally go to the comptroller's office, but it might very well be the Maryland State Central Collections Unit that does that at the point where it gets into a bankruptcy proceeding. So you know, I don't think MEA would necessarily be equipped to do it or participate in that proceeding normally. So.
Okay. Well, since we're talking about it, so who would instigate that? I mean, would that be MEA, or do we need to do that because of our proceeding today?
Well, in bankruptcy, they have to send out a notice, you know, regarding bankruptcy, the bankruptcy proceeding to potential creditors. I mean, we have to do it with respect to the bond because the commission is the named obligee on the bond. But I don't think the commission would necessarily do it with respect to the alternative compliance penalty. I don't think that is, you know, beyond what's on the bond. Again, I think it would probably be the state central collection agency, which is also probably the agent, but I don't know for sure.
Okay, I would just encourage maybe staff, we don't have to continue this at this proceeding now, but if this is still an ongoing concern, there might be funds available. They do owe the state the alternative compliance fee, and that fee is supposed to go to the CFIT that's you know, that is run by the Maryland Energy Administration. So anyway, nothing else.
Commissioner O'Donnell.
Just a follow-up. The bond itself is paid by the company that the bond was obtained from, right? Doesn't come
paid by the surety, the insurance company.
Yeah, okay. I just wanted to clarify that. And you're talking about filing a claim against the estate for the remainder of the compliance obligation. Is that right?
Right. Well, I think what happened was the commission should have received notice from the bankruptcy court to file a claim by a certain date. I'm not a bankruptcy.
That's not for the bond money. I'm just clarifying that.
That would no, it's not. It's for the rec payment.
Right. I got it. I just wanted to clarify that and get that on the record. The bond money and the remainder of the obligation are two different things.
Correct.
Seeing no additional questions, I would move that we find the company is unable to meet its Maryland obligations, that we approve the cancellation request, and that the commission collect on the company's surety bond. The vote begins with Commissioner Herman.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 6 on today's administrative agenda, the final item is a request from Exelon Corporation for an extension of time to implement merger condition number 10B in case number 9271. On this item for staff, we have Michael Dean, and for the company, Kerry Hill Allen.
Thank you. Good morning, Mr. Dean.
Good morning, Chairman, Commissioners. Michael Dean on behalf of staff. Item 6 is a request for an extension of time to December 31, 2024 to implement condition number 10B from the 2012 merger with the Exelon Corporation and Constellation Energy. This condition, which was approved in order number 84698 in 2012, requires Exelon to develop or assist in the development of 125 megawatts of Tier 1 renewable resources in Maryland within 10 years of the close of the merger, of which 62.5 megawatts is to be from wind energy. The condition itself allows for its extension for reasonable delays in permitting or zoning that are beyond the project developers or Exelon's control. In the event of a failure to complete the merger condition, the condition itself has a provision for liquidated damages based upon a per megawatt basis for any capacity shortfalls. Exelon reports that it has met 70 megawatts of the 125 megawatt requirement through the 40 megawatt 4 Mile and 30 megawatt Fair Wind projects, and intends to satisfy its remaining obligations under the merger condition with the Dan's Mountain Wind Energy Project, which will provide up to 70 megawatts using 17 turbines located in Allegheny County. However, this project has been the subject of litigation over its permit and zoning. The Commission on June 10, 2020 granted a CPCN exemption under Public Utilities Section 7-207.1 to construct the Dan's Mountain Energy Wind Facility, and this decision was appealed to the Court of Appeals, which held legal argument on the case on September 9, 2021. The zoning for the project is complete and has been reviewed and approved by the Court of Special Appeals in a August 16, 2021 decision. The Exelon filing states that it has determined that the Dan's Mountain project can reasonably be expected to be completed by the end of 2024, and in its filing requests that the merger condition deadline be extended to December 31, 2024. The filing notes that Exelon is prepared to execute a offtake agreement for the facility should the extension be granted. Staff has reviewed the matter and in its comments notes that Exelon plans to spin off its generation in a corporate transaction that should close in the first quarter of 2021. Following the spinoff, the obligations under the merger condition would still remain with the remainder company, Exelon. Staff concludes that the criteria for the extension of the merger condition has been satisfied and that the requested extension should be granted. Staff notes it is also state policy to develop Tier 1 renewable resources located within Maryland. Staff recommends that the Commission grant the requested extension of time to December 31, 2024 to complete merger condition number 10B. The Maryland Energy Administration and Maryland Department of Natural Resources Power Plant Research Program in a October 28, 2021 letter, mail log number 237604, stated that they do not have any objections to Exelon's request.
Thank you, Mr. Dean. Counsel for Exelon, do you have anything additional to add?
Your Honor, this is Carrie Allen for Exelon Corporation. I think Mr. Dean summarized it well, and we're just available to answer any questions that you may have. Thank you for your consideration of our request.
Thank you. Do commissioners have questions of this item? Commissioner O'Donnell.
Just briefly, what is the status for staff counsel? What is the status of the Court of Appeals case again?
Oh, go ahead.
Excuse me, you probably know better, but oral arguments have been held and we're awaiting the decision of the Court of Special Appeals. And
I know it's not,
and it has not yet been issued.
I know it's not possible to predict when a decision may issue forth from the Court of Appeals. It could be tomorrow or it could be a year from now. Well, what happens if they decide to overturn the Court of Special Appeals?
Well, I think in that case, there's still an appeal right. So I can't speak for the developer, but I would imagine they would pursue their legal rights there. What we've tried to do by asking for a deadline of December 31, 2024 is build in sufficient time to have, you know, some slippage in terms of, you know, if there are any additional legal obstacles, yet make sure that we won't have to come back to the commission and ask for another extension. So,
What would the developer's appeal right be if an adverse decision is issued from the Court of Appeals?
I think they have the right to petition. I'm not an expert on, you know, I don't represent them, so.
Well, you're the one that mentioned they had an appeal right, so I thought you might have some basis for saying that.
Yeah, so just like with the companion case on the zoning, there was a right for the folks to seek an appeal to the, you know, within, I can't remember the number of days, and they didn't elect to seek their appeal right. So
Yeah,
I think the
my-
same would
my-
be here.
My experience is Court of Appeals decisions are pretty final. They're the Supreme Court of the state of Maryland. I guess a petition for rehearing may be possible. I don't know, but I doubt that ever happens.
Commissioner, the current case is with the Court of Special Appeals.
Oh, I thought you said the Court of Special Appeals issued an order in August and that oral arguments were heard at the Court of Appeals in September.
So
That was,
there are two cases. I'm sorry, there was a zoning case and a decision was issued by the Court of Special Appeals, and then there was a time period by which a petition could be filed, and that time period has elapsed. So that case is done. This is my understanding. There's a second case that relates to the CPCN exemption. I believe the commission's own Miles Mitchell argued that case for the commission back on September 9th. When that decision is issued, I believe there will be the same period by which a petition could be filed. But my understanding is that it's very rare that these petitions are granted, maybe less than 3% of the time in Maryland. So that, at least that's my understanding of the facts. Like I said, I'm not counsel for the owner or developer.
Okay, thank you for that clarification. I didn't realize there were two court decisions. They were kind of being intertwined here, maybe a little bit, at least in my mind. So thank you.
Any additional questions? Seeing none, I would move that we grant the requested extension of time to December 31st, 2024 to complete merger condition number 10B. The vote begins with Commissioner Herman,
Aye.
Commissioner Linton,
Aye.
Commissioner O'Donnell,
Aye.
and Commissioner Richard.
Aye.
I vote aye. The motion is approved. We will not have a weekly administrative meeting next Wednesday. Our next administrative meeting will occur on Wednesday, November 17th. Have a great day. This meeting is adjourned.
Thank you.